A mover and seconder, Columbus, Brunton. Moved by Columbus, seconded by Brunton, that the application of DeCarlos Farms Limited, 899 Charlotteville Road 5, R2 Simcoe, affects the lands described as Part Lot 1, Block 8, Plan 33B, Geographic Township of Charlotteville, Norfolk County, to amend the Norfolk County zoning bylaw 1Z 2014. File numbers before you. This is to be approved for reasons set out in report number DCS 17-74, and that no public input was received and therefore was not considered as part of this decision. Discussion on this motion. Those in favor? It's carried. Thank you. The second application. I have a question, Shannon, if I may. I noticed on the last application, the address was R2 Simcoe, which I know I live at R2 Simcoe in Hillcrest. That seems a long ways out for R2 Simcoe. I'll just leave that comment, or didn't it say that? You got that? I noticed this one doesn't have RR2 on it. It's pretty close to the other lot. I think maybe that RR2 Simcoe might just not be correct. Anyhow, we can correct that later. Yeah.
Through you, Mr. Mayor, we can verify that and confirm with our clerk's department tomorrow.
Yeah. Okay. No, just curious. Okay, the second application. Wells has moved. I'll need a seconder for approval. Geisens has seconded that the application by estate of Benjamin Dawson, Mary Dawson, 3 Pickett Boulevard, Richmond Hill, affects the lands described as part of Lot 1, Block 6, Plan 33B. This is in the geographic township of Charlotteville also. Norfolk County is to amend our zoning bylaw 1Z 2014. This is for reasons as set out in report 1775. No public input was received, therefore not considered as part of this decision. Discussion. Those in favor? It's carried. Page 111. This is staff report DCS 17-76. This application has been received to provide relief on a site-specific basis of Section 3.11.1 to permit the construction of a dwelling without frontage on an open, constructed and year-round improved street and relief of 8 meters from the required front yard setback of 13 meters to permit a setback of 5 meters. Paul Murphy and agent Brad DePorter has put forth this application. Affects the lands described as Gowery Street. I will now open the public meeting on this staff report 17-76. I know that Kayla is here and she's quite eager to give her report. Thanks, Kayla. Good to see you. Thank you.
So this is a zoning application to permit the construction of a dwelling without frontage on an open, constructed, and year-round improved street. The application is also seeking relief for the front yard setback. The subject lands are located just outside of Port Dover and are vacant with some trees, and located with Lake Erie to the south and residential dwellings to the north and the east. Council will be familiar with the 2 vacant lots, which are to the south, where residential development is anticipated. The subject lands are accessed off of Cumberland Street, which is also an unmaintained road. Both the official plan and zoning state that development shall only be permitted where frontage and access is to an open and public road that is maintained on a year-round basis. Construction of a single detached dwelling on lands without adequate frontage does not represent good planning and is not in the public interest. Access for residents, services, and emergencies are critical. The frontage at this point along Gowrie is simply an uneven grassed area. Relief for the front yard setback to permit a setback of 5 meters has also been requested, and the proposed relief is appropriate and it is in keeping with the other setbacks along Gowrie Street. Overall, the proposed amendment is not in keeping with the intent of the Norfolk County official plan and the Norfolk County zoning bylaw. The amendment could set precedents and affect other properties in Norfolk County without adequate frontage. Planning staff are recommending refusal of the application. Thank you.
Kayla, thank you. And questions to the planner from council. Councillor Wells, please.
Thank you very much, Mr. Mayor. Mr. Mayor, on this application, I must say I'm somewhat confused, and that's not hard for me to be confused, as you know by now. But I thought we dealt with this some time ago with another application in the exact location down in Cumberland and Gowrie, and we approved that. How is this one different than the one that we approved? Because we dealt with all 10 lots. We knew it was a record of, or 10 lots subdivision many years ago. We approved some, and now we're not approving this. The road is still exactly the same road, is it not? So I'll sit down now.
Through the mayor, to Councillor Wells, what you're referring to are the 2 lots directly south of the subject lands. Those were site-specific amendments that dealt specifically only with lots 1 and 2, and so relief was only granted for those specific properties.
Well, again, Mr. Mayor, might I ask a follow-up question? How is this application different than the 2 that we approved?
Through the mayor, this application is different because it is it was not dealt with through those other planning applications. This property is designated and zoned agricultural, so we aren't looking for a specific building envelope or a slope stability study in this case. We're simply dealing with permitting development on a road without proper frontage.
This will be the last question I ask, Mr. Mayor, because I'm still confused, but it's not your fault. Did we not approve 2 lots on an unopened road allowance just several months ago?
Through the chair, yes, you did approve that for lots 1 and 2, and this is a different lot that is also vacant on the same unopened road allowance.
Never mind. Thank you. Okay.
Sometimes we disagree with staff, and sometimes they disagree with us. I think that's a good thing. But you get to vote, and staff doesn't. Okay, Councillor Oliver, then Brunton.
Thank you, Mr. Mayor. My first question is somewhat related to my colleagues, and I apologize to staff for my back. But Kayla, I think you made reference to the fact that staff, as one reason for recommending refusal, is the risk of setting precedent. And similar to Councillor Wells's question a moment ago, did we not, in a sense, deal with the issue of precedent when we dealt with the other 2 lots on the south side of Gowrie? So the issue around precedent shouldn't really apply in this case.
Through the mayor to Councillor Oliver, yes, that is correct. Staff typically always recommend refusal for development without frontage, but you are correct, council did approve the relief for lots 1 and 2, within the last few months. So yes, that's correct.
Thank you very much for that. My second question is also on the first page of the report, and I see that it says, just below the recommendation, it says, it should be noted that the application did not include an OP amendment. Should council wish to approve the application, an OP amendment application will need to be brought forward. This may seem like a silly question, but I'll ask it anyways. Should council decide that we want to approve this application for relief and for the zoning amendment, is it legal for us to also add text to the motion that would approve the OP amendment? or an OP amendment?
Through you, Mr. Mayor, Councillor Oliver, no. Simply because appropriate notice under the Planning Act
Okay.
has not been met.
I assumed that was the case, and thank you for that, Pam. It's frustrating in a way, though, because obviously, if someone was objecting to the application to amend the zoning, they should be here to object, just as they would if they were asking for an OP amendment. But I respect that answer. Thank you.
Thank you. I have Councillor Brunton and then Councillor Black.
Thank you, Mayor Luke. I, like Councillor Wells, am somewhat confused, and I kind of had a hunch back when I believe it was a year or two ago we started dealing with this area. And I'll tell you what I'm wrestling with. Here's we'll call it 10 lots. I think 8 and 9, are they not? Isn't there one house that straddles the line? If I'm not mistaken, that takes up the 2 lots. However, 10 lots, and yet we keep chipping away at this with roadways that aren't up to our standard, both areas, Galway and Cumberland. Yet we have all kinds of developers, one recently in Dover where we said you have to do all kinds of subdivision work, curbs, underground sewers and that. And I realize it may be difficult out here, but the roads are not assumed by us, correct? Correct? So where do we start at some point? I can see your point in not allowing the application, but somebody should be upgrading these facilities. We're going to have possibly up to 10 homes in there maybe, or at least 9 if the ones take up the entire lots 8 and 9. And I guess if we let this go, continue, there's what, 3 or 4 more vacant lots there to be developed, possibly? They're going to keep coming. And where does it stop? And I guess I have no problem with them development, but I would like to see it, because next thing they want, we'll want full municipal services. And at some place, we have to say to the, enough's enough. So anyways, I'll leave it at that. Thank you.
Councillor Black.
Luke, thank you very much. Through you to Alicia. Yeah, I just wondered, how many similar properties do we have like this throughout Norfolk County? Not an exact number, but like, are there a lot?
Through you, Mr. Mayor, we don't have an exact number, but a lot would be a good guesstimate.
Okay, so, and your warning of precedent, so if we do this, then all those other lots of lots on unmaintained, unopened road allowances would have the right to come here and for an approval of that, of their property for development.
Thank you for your comments, Councillor Black. Planning staff look at each application on its own merits, but it is my assumption and professional opinion that in most cases we will be continuing to recommend refusal if the road is not maintained.
Okay, so, and just like Councillor Brunton has indicated, if we do go ahead and allow this and all the other ones, we could be susceptible to liability, to providing services, snow removal, garbage pickup on roads that aren't to our standard.
Through you, the mayor, I'm looking at our county manager and he's saying yes. From a legal perspective, you may recall too, I want to bring back to council's attention the reports that Ms. Rell brought a few months ago had the same comments from Public Works and Environmental Services that are on page 113 of the planning report again this time. And some of those issues were brought up at that time and council chose neither of those options.
Okay, so thank you very much. And it makes me wonder if really, if we go ahead with something like this, if it's in the best interest of all the taxpayers. Well, I'll wait until the debate, so I'll make that point at that time.
Thank you, Councillor Columbus.
Thank you, Mr. Mayor. The planners are recommending refusal, but look on page 116, under Norfolk County zoning bylaw 1Z 2014, second paragraph, it almost sounds like you're kind of sitting on the fence. It says, second sentence, after conducting a site inspection, planning staff are of the opinion that the requested front yard setback relief is appropriate and in keeping with the other setbacks along Gower. So if this got turned down or approved the opposite way to what the recommendation is, would you be recommending that this go to an OMB hearing of that nature?
Through the mayor to Councillor Columbus, I can comment on that paragraph. There's two separate aspects of this application. The first deals with frontage, providing relief of frontage on an open and maintained road. And then the second aspect deals with the front yard setback. So the paragraph under the zoning bylaw that deals with the front yard setback just states that planning staff do support that it would be appropriate for the dwelling to have a 5-meter setback.
Any further questions? Oh, yes, sorry, Councillor Brown.
You to staff again, if I may. Options 1 and 2 in your report, have you provided them to the applicant?
Through the mayor, options 1 and 2 have been provided to the applicant through the previous applications as well. So the applicant is familiar with the comments from Public Works.
What's his comment? Like what, doesn't like either one of them?
Through the mayor, I will let Brad comment on that when he does come up to speak.
Thank you.
Microphones, thank you. Anything further? Is the applicant Paul Murphy or agent Brad DePorter here? I don't see, Brad, you're here. I know you're here. I saw Paul earlier and he's not here. So is there anyone in attendance who wishes to speak in support of the application? And certainly Brad is the agent if you wish to speak. Now is your time. Thank you.
Mr. Mayor, members of council, my name is Brad DePorter, and I recently purchased Lot 10 on Gower Street from Paul Murphy. Paul Murphy started this application and was the applicant for Lot 1 also that went through with Bob Harris. And my wife and I plan to build a house and a garage on Lot 10 and become our permanent home. It's kind of our goal. This is why I've submitted the application. I believe council should approve this application based on several reasons that Tom Klein outlined back on May 9th about it being a planned subdivision and obviously being able to provide access to a planned subdivision. There was a lot of legal information that he did provide at that time, and a lot of that led to you guys approving the applications for Lot 1 and 2 at that time. We've actually looked at a bunch of the road issues and discussed those. Council on September 5th, I was here, and actually we did talk about doing some improvements and being able to upgrade the road. Our plan is to do some improvements to the road to make it better. I think, again, Paul Murphy and Bob Harris and the other landowners that are there don't feel that it's necessary to necessarily bring the roads up to total county standards. And I think the biggest problem really is Cumberland. We don't see that Cumberland was created by the landowners there. It was created by the city of Nanticoke, and we believe it's the city of Nanticoke's challenge to do that. We would be able to look and make Gower Street acceptable and try and bring it up to a standard, and we're working with Sean Van Acker now already in the roads department to do some of those upgrades. I think that's it. I'll keep it short.
Thank you. Questions to this gentleman? Yep. Mr. Brunton, to Mr. DePorter, please.
Yes, Mr. Porter, you said that Cumberland is the county, former city of Nanticoke's responsibility?
It was created by the county, yes.
It was?
Yes.
How long
it was
ago?
upgraded?
Has it been done recently?
A long time ago.
A long time ago. And I asked the question about options 1 and 2. Have you considered both of those?
I have, yes. And like I said before, I bought the property based on what was going on. We didn't necessarily feel we would have to basically bring the road up to county standards. So we don't necessarily want to put that type of cost into it. I think that makes it unfeasible, I guess, to develop at least for 1 lot or 2 lots. Again, if you were going to develop all 10 lots, I guess you could see that it would be worthwhile doing.
We talked to the other property owners about contributing towards that?
We have, and I think Bob Harris, who is the other person right now that's interested in building in that area, is certainly going to cooperate and to work through that. The problem is the other landowners that are there are already the property owners that are there. So Kim Murphy owns Lot 8 and 9, also owns 7 and 3. So she's a current resident, has a property there. She owns 4 of those lots. And Hillary Robinson owns 5, 6, and 4. So it's really the other 2 existing owners own the rest of the lots that are there.
So I'm assuming at some point, lots 1, 2, and 3, 7, well, you say 10 is the one, all those we're going to develop at some point. So there's going to be, I'm going to say at least 9 homes in there. That's my long-term vision for that area. And I guess, if you improve the road yourselves, do you expect the county still to look after it? Or not to look after it? What's your...
Well, I think what we said in September 5th is we would improve the roads and that we would have to continue to maintain it. So.
Okay, thank you.
Further questions? Thank you, Brad. Is there anyone else in attendance who wishes to speak in favor of this application? Is there anyone in attendance who wishes to speak in opposition or in general to this application? Further from council? Councillor Columbus.
Mr. Mayor, we heard from the applicant about the ownership of Cumberland. He indicated that City of Nanticoke actually put that road in there, I guess, years ago, or the predecessor to that. And I just wonder, have we had a legal opinion on the ownership of that Cumberland Street? Or Cumberland Lane, I guess it is.
Well, I don't know if I can give you the right answer. We certainly haven't discussed a legal opinion of that road to my knowledge. And we've had several discussions about this. I would think because this is a plan of subdivision at one time, appears to be that a road was put in to connect it to public access. Don't know.
Perhaps it's time that we had a legal opinion, and maybe staff can follow that up.
Well, Mr. Baird, I don't want to start bringing things into this application as something we can deal with separately, getting a legal opinion. Mr. Baird, do you wish to comment or give me some direction on how to
Absolutely,
proceed?
Mr. Mayor, just to help you out on Councillor Columbus's
Thank you.
question. Page 4 of the report, 114 in the agenda. There's some comments, that first paragraph under property management. This has been reviewed by Lydia Harrison and our legal people. That defines what Cumberland and Gowrie are in terms of legal operations. Mr. Van Acker, Mr. Crittenden, and I, both as former roads managers, lived and breathed this road, and it's just a matter of time. But that is the legal interpretation of those 2 roadways.
Okay, thank you. Anything further? You okay, Councillor Columbus? Anything further from council? I will need a mover and seconder to close this public meeting. Councillor Wells has moved. Councillor Sonnenberg has seconded that we close the public meeting. Those in favor? That is carried. Thank you. What's your wishes? Councillor Black.
I'd like to move the recommendation in the report, and if we get a seconder speak to it.
This is for refusal?
Yes.
Do I have a seconder? Mr. Brunton? Black has moved. Brunton has seconded that the application by Paul Murphy at 1260 Front Road Certainly not Front Road Street, St. Williams. Or is that Paul's address? Thank you. I'm sorry, I got hung up on the former 2 lots in Forestville. The application by Paul Murphy, yes, at 1260 Front Road, St. Williams, Ontario. This affects Plans described as Lot 10, Plan 288. This is in the township of Woodhouse, Norfolk County. This is to amend our zoning bylaw 1Z 2014. It is recommended for refusal for reasons set out in the report number DCS 17-76. Councillor Black, please.
Thank you, Mayor Luke. I understand the dilemma down there, but in the bigger picture, I think it's also important to consider the rest of the taxpayers of Norfolk County, because if we do allow this sort of activity to occur, it will come back to Norfolk County and the taxpayers in terms of liability, in terms of having more pressure to provide more services, problems with access in terms of fire, ambulance, and OPP, if there's problems down there, and we cannot get down to service these people, then there will be a huge liability issue. I can see court cases, and it all ends up in the lap of the taxpayers of Norfolk County. This is only one small area, and there are many, as we heard from staff, many, many, many more situations like this. It's a can of worms. If we open it up, I predict a lot of problems for Norfolk County, increased costs for Norfolk County taxpayers. I've been on council for a while, and I can recall the first time that one of these types of applications came forward with the town of Simcoe, and I think Councilor Brunton was the Public Works Director at the time, recommending refusal. And I couldn't quite understand why at the time, but it was explained to me, and since then, anytime one of these has come up, I have consistently voted against it for the reasons that I've just given.
Thank you. Councillor Wells.
Thank you very much, Mr. Mayor. Mr. Mayor, I will not be supporting the motion that is on the floor. I certainly understand that we have created a situation, but it was we who sat around this table that created that situation by agreeing to the development of the two lots that were there. And I think it didn't take a genius to figure out that there were going to be more applications in exactly the same area. I mean, that just didn't come, and we have to accept some responsibility for that. Maybe what we should be doing is looking at ways to get the road improved, if that's what we want to do. But to deny the application after having already approved two, I just don't know what the logic of that would be. Thank you, Mr. Mayor.
Thank you. Councillor Oliver.
Thank you very much, Mr. Mayor. I too will, I don't think, be able to support the motion on the floor. Councillor Wells has already reminded us of the approval we gave to the two lots to the south, which in fact, if anything, have far more issues related to those lots than this lot does on the north side of Gowrie. The other thing I want to do, Mr. Mayor, and it was mentioned briefly, and I think Mr. DePorter's comments, I want to just read to Council, if I may, the motion we passed on September the 5th relating to this exact thing. And while I agree with my colleague about concerns over the road standard, I would suggest this would be different. Every one of these, as staff said, would have to be looked at on its own merits. I'm aware of another one that's going to be coming, I hope, to council in my ward. And the issue there is even a far smaller issue in terms of access from an unopened road to a road in the Turkey Point area. But that's for another day. But this is what we passed back on September the 5th. And it was moved by myself and seconded by Mr. Mayor as a councillor of council and committee. That staff report PW 1761 Gowrie Street Road Improvement request be received as information, and that council permit Brad DePorter to make improvements to the Gowrie Street and Cumberland Street allowance as per the request, and that Mr. DePorter be required, and obviously other property owners, not just him by default, be required to maintain said improvements in the future, and further, that council allow the road improvements to be done to less than municipal standard, as both Gowrie Street and Cumberland Street will continue to be unmaintained. Any issues around precedent and liability, et cetera, I think were covered in that particular motion. And so, Mr. Mayor, I was quite comfortable reading the report tonight in being able to approve this request, not refuse it, because of these other two decisions we've made, and most particularly about this road back on September the 5th.
Thank you. Councillor Brunton?
Well, thank you, Mayor Luke. Mr. Baird, sorry,
Mr. Baird,
Mr.
it's
Baird.
still Mr. Baird.
I'll recognize you. Pointed out that we own these roads. And to me, to use a road that's unopened, you have to pass a bylaw to open it. That's my understanding of it. It used to be that way. You had to pass a bylaw to open a road allowance. And I have no problem with these lots developing, but I would like to see some form of an agreement with the landowners on the 10 lots to tell me that they're going to upgrade those roads to an appropriate standard. And I'm not saying they have to be totally upgraded to our municipal standard, but I'd like to see it in writing, agreed to by this county, because we know darn well that the rest of those lots are going to develop. And I think that's only fair, that we have all these people together say, okay, here's what we're going to do with this unopened road allowance, and then we can pass a bylaw to open the road allowances and maybe even maintain them in the future, because that'll be the next step. Once they all build on them, they'll come back in the future, maybe not this council, and say, oh, well, these are your roads. We'd like you to plow them. We'd like you to put garbage up. All those things are going to happen given time. So I'd like to see an agreement, and if our motion is defeated, I'd be prepared to make a motion that staff enter into an agreement with the property owners, specifically while there are still lots available that are open, so the new owners, I'll use that word, can get on board with Mr. DePorter and come up with a solution to fix the roads that we can open and maintain. Thank you.
Any further discussion on the motion for refusal? Hearing none, I'll call the question. Those in favor of the motion? Those opposed? Motion is defeated. It's all right. Further direction. Councillor Wells?
Mr. Mayor, I'd be willing to put forth a motion that we approve the application.
Do I have a seconder for approval? Councillor Oliver? Wells has moved. Oliver has seconded that the application by Paul Murphy at 1260 Front Road, St. Williams. This affects the lands described as part of Lot 10, Plan 288, Geographic Township of Woodhouse in Norfolk County, and this is to amend the Norfolk County zoning bylaw. File number is there, and it be approved. Yes.
Just before council proceeds, I just want to mention that usually we approve the official plans before the zoning bylaws. So this is a bit unusual in that staff are saying there still is a requirement for an official plan. So if you approve this, the staff will, I assume, prepare a zoning bylaw and put it on there, but it's kind of putting the cart before the horse in terms of our process.
Through you, Mr. Mayor, there's no opportunity for conditions through zonings.
Thank you. She said there's no provisions for conditions in a zoning application. And we have gone through the public meeting, and this motion is on the floor, and I'm going to proceed to deal with it, and then we'll go where we go. Councillor Oliver, please.
You already have a seconder, Mr. Mayor?
That would be you.
Oh, yes, I'm happy to be the seconder. Then I'll speak if I get a chance.
Thank you. Would you like to speak?
Well, I'd let Councillor Wells go first as a mover if he wishes.
I don't know if I want to hear from him, but I'll hear from you first.
Well, thank you very much. I don't have much more to say, Mr. Mayor. I'm quite comfortable with this recommendation at this point to approve this application for reasons we've cited before. I respect my councillor's comment about assurances around the road and needing to have the consent of other owners. As far as I'm concerned, the decision that was made on September the 5th, Mr. Mayor, sets the county's policy with respect to this road. Full stop. Continues to be maintained as an unmaintained road assumed by the property owners in terms of maintenance standards. And if at some point in the future, when those lots are potentially all developed, the council of the day will have to consider whether or not it wishes to change that. And quite frankly, if I were here at that time and there were 10 homes on that road, I might consider it worth improving at our expense, because we now have 10 homes there instead of 2 that have been there for the last 40 years. So, Mr. Mayor, I think it's a good recommendation to approve it. I don't think we're setting a precedent, and I think we have ourselves well protected with respect to the standard on that road. Thank you.
Thank you, Councillor Black.
Through you, Mr. Mayor, to staff, to Pam. What you're saying is that we need an official plan amendment as well?
Through you, the Mayor, to Councillor Black, that's correct. It should have been these, both an official plan amendment and zoning bylaw amendment should have come forward at the same time. It was staff's error in that we didn't catch it. We recognize that it needs to happen to clean this up, but what I would suggest that if council would like to approve the application, that in your decision you outline that an official plan amendment needs to come back, and staff will make sure that that comes back in a quick manner.
Okay. Well, I would suggest that the mover and seconder consider adding that.
We can't add a condition on here.
It's not a condition, it's just as Pam said.
Okay, so you're saying now that it's not a condition.
So through you, Mr.
So
Mayor, you
what
can't,
would I add to the motion?
the second piece of the recommendation, yeah, that it would say that staff be directed to process an official plan amendment to deal with the frontage on the road,
To deal with,
the road frontage.
and I got most of it, that staff be directed to,
Process an official plan amendment
process is the word I was missing. An official plan amendment to deal with the road.
road frontage. Road frontage.
Thank you, I'm getting old in my hearing.
My apologies.
The road frontage, thank you, Pam. Back to Wells and Oliver as the mover and seconder, that staff be directed to process an official plan amendment to deal with the road frontage. Are you okay with that, sir? Go ahead, yes, you may speak to that.
Certainly in favor of that, Mr. Mayor. I wonder if it would be appropriate, and Pam Dusling acknowledged that staff should have brought this forward. In other words, it's our error internally within the county. Could we have as part of this further clause that we waive the fee for an OP amendment application? Because I would suggest that's appropriate in this case. If the applicant should have been advised at the first meetings to do both together, and he wasn't given that advice, I don't think we should be charging him a
Well,
fee.
we certainly as council have that authority. Councillor Wells, would you want that included on here? Are you in support of it, or do you want it, we can do that as a separate
Could we
motion?
ask how much it is, Mr. Mayor?
Official plan amendment, Mr. Baird, does Pam, are you roughly?
We'd be prepared to endorse what Councillor Oliver has suggested. And want to de-emphasize, it wasn't necessarily an error, that this would be the right thing to do.
So the motion for approval would have added to it, the staff be directed to process an official plan amendment to deal with the road frontage, and further that the fee for the official plan amendment be waived. Okay? Okay, Mr. Seconder? Okay. Councillor Black, and then Brunton.
Question, what is that fee? Is it around $3,000?
Through you, Mr. Mayor, I don't have the number right offhand. I think both the zoning and the official plan amendment together are about $3,000.
Okay, thank you.
Councillor Brunton?
I'm just wondering, if we should not pass a bylaw to open the road. Still unmaintained, but we're asking for people to use our property as a road. We're encouraging development, and I'm just wondering if we should pass that bylaw to open it. Are we not liable for that?
Mr. County Manager?
Whether or not that's something this council wishes to consider at a future point in time, that's well beyond the scope of this application. You've received the advice from your professional staff was not to do this at all. It's very much your right to go against that, but certainly we might go from a position where someone without a fundamental legal right to build on these properties at all of a sudden will end up with a paved, plowed, serviced road. That's something council needs to consider through its normal process, and amongst other things, receive some sort of costing and estimate from staff. There'd be a fulsome process there. I don't think you may wish to direct staff to bring you reports to that effect. It's well within your right, but I don't think you can deal with that within the process of this public hearing, would be my advice to you.
Any further comments on the approval resolution before us? I'll call the question. Those in favor? Those opposed? That's carried. Thank you. I now would like to go to page 145 of our agenda. This is staff report 17-49. It's the Long Point Source Protection Plan implementation through the county official plan and zoning bylaw amendments, MMA comments. I now open the public meeting on the staff report 17-49. Mary Elder is here. I want to say thank you, and you'll introduce our guest, and I'm sure, and I want to say thank you for your patience in letting us get through that, and we'll move on. Thank you.
You're welcome. I have with me tonight Pierre Chauvin from MHBC, who's done the volume of the work on the policies, first when they went into the source protection plan itself, and then has worked with us on the actual amendments we'll be considering tonight. So it was back in October of 2016 that the background report and a draft bylaw for the official plan amendment and zoning amendment were brought to this council. Municipal Affairs were sent those bylaws to see what their comments were and got back to us in February. I've attached their comments from that time as attachment 1 to the report. With the official plan review, this has taken a bit of a back seat, but with this little bit of a break, we've been able to bring it forward finally and hope that tonight we'll be able to complete this aspect of our source protection plan. The draft amendments that were brought forward last year were revised to address the provincial comments that came in February, and then staff circulated those revised draft amendments to Municipal Affairs, Public Works, Bylaw Enforcement, back to the Lake Erie Source Protection staff, and Long Point Region Conservation Authority, and to Oxford County, so that we could just get a more fulsome response on the various policies and the actual amendments and how they were looking. What resulted was a series of comments that were very beneficial, and those, for the most part, are attached to the report, and they were used to further revise the draft bylaws. The recommended official plan and zoning bylaw amendments are attached as attachments 6 and 7 for ease of reference, but they also are separate under your bylaw section of your meeting tonight. The recommended, on page 3 of the staff report, many of the changes to the bylaws from the October 2016 version are outlined. So there's new schedules about highly vulnerable aquifers, significant groundwater recharge, and new information on wellhead protection areas D and E. And we've removed the vulnerable area scoring in the text just to make it simpler. If someone needs that technical work, they can go to the assessment reports and look at that. The policies that are in the bylaws before you tonight are required by the source protection policies themselves, and they modify the current source water protection policies that are in our official plan and zoning bylaw. So I'm going to pass over the presentation now to Pierre to provide further information.
Thank you, Mr. Mayor, members of council, members of the public. My name is Pierre Chauvin with MHBC Planning. And I just want to take the opportunity to thank your staff. We've been working with Mary for several, almost a couple of years now, dating back to the original days of the source protection plan with the Lake Erie Source Protection Authority. So it's been a while we've been at this. And so what I intend to do is quickly go over sort of some recap. If you recall, I was here about a year ago, almost to the day, with the background report, and a lot of this information is just sort of recapping some of why we're doing this and what is it really doing. So, with respect to the source protection plan itself, a lot of this is very complex and scientific analysis that has been done across the province, and a lot of the information in source protection plans and the technical data is contained in what they're called assessment reports. And those form part of the background that fed into the development of the source protection plans themselves. And it's the plan itself, in this case, the Long Point Source Protection Area plan. It contains the specific policies and regulations that are intended to protect and regulate certain significant drinking water threats, and I'll speak to those in a moment. And that particular plan was approved by the local authority here in 2015 and ultimately approved by the ministry on July 1st, 2016. And it's on that effective date that all your decisions, including planning decisions, have to conform with the source protection policies. So notwithstanding the fact that we're here amending your official plan and zoning bylaw to implement this, all your decisions since July 1st, 2016 should have been consistent with the policies of the source protection plan. Within the source protection plan, there are deadlines for updating and amending your own official plan and zoning bylaw, and that's why we're effectively here, is to do that as a conformity amendment to implement the various policies of the source protection plan. I don't tend to even imagine to read this long list. It's the 21 prescribed drinking water threats under the Clean Water Act. The bottom three deal with water quantity matters, so the balance of the majority of the drinking water threats are water quality issues, so things that could affect the quality and the quality of the water. So many of which, application of agricultural source material, manure, non-agricultural source material, sewage, sludge, even storage and handling of organic solvents, oils, degreasers. So I would consider many of the threats are either categorized into industrial type uses or farm or agriculture related type uses. And then I should just note that the policies that we have before you today don't really relate to those water quantity threats at this point in time, as there are still Tier 3 analyses going on underway to determine whether that is, if those particular threats would become an issue here. Again, as part of the amendment, we've included various schedules which are already in the source protection plan, which identify and model your wells. There's, I believe it's, if I recall, about 20 wells. I'm just losing memory here, but there's about 19, 20 wells that are within the county, and as well as an intake protection zone. And most of the threats or prescribed threats are only an issue within those red areas that are highlighted on this plan, and then to a lesser degree, as you move further away from the wells, the other threats aren't as affected. So you can see on the table to the right, we've listed all those various threats, prescribed threats, and the red column would indicate, well, that's where that particular policy or you would be concerned about that particular threat, and how that corresponds to where it is geographically in relation to the well on the red area on the wellhead capture zone. And you can see as you move into the various portions of the well, a lot of the threats tend to drop off, and so you get into the orange areas, and only sewage and waste disposal and Dean apples are sort of the most significant threats, and so on and so forth. So most of the regulation and control is related to those particular red areas, and they're generally pretty confined within your county. And like I said, the source protect. So where this is all coming, the authority is coming from, is the Clean Water Act and the source protection plans that establish the policies, and these policies either prohibit or restrict certain threat activities that are deemed to be vulnerable. And so those vulnerable areas are those wellhead protection areas, your intake protection zones, or IPZs. A lot of acronyms in this world. And they vary depending on the circumstances. So it's a very difficult way to try to regulate this in the planning world. So and you'll see how we've dealt with this, is essentially defer a lot of this decision-making to your risk management official, which is a new body that's created under the Clean Water Act. And that particular official has a lot of authority under the Clean Water Act to be able to regulate and control much of the significant drinking water threats. So much like you require a permit from a conservation authority, this is very similar to that. So you may be permitted to do a certain activity or use, but you would need to get that permit or that approval from, in this case, the risk management official to proceed. So in the source protection plans, they deal a lot with existing uses and future uses. In the planning world, we can only deal with those future uses or change in land uses. But under the Clean Water Act, it does allow for that risk management official to be able to control existing uses that are out there, and to approach those particular activities or people who are undertaking activities, to engage them into perhaps requiring them to prepare a risk management plan. So that's a whole other area that we're not getting into. We're dealing with those future uses and those change in land uses. And again, there are many other tools that we can use to our disposal to deal with either those future threats. There are certain threats that can be dealt with through already prescribed instruments. There are things out there already. The Nutrient Management Act, for example, requires nutrient management plans, those types of things. So some of those things are already taken care of, and the source protection plan recognizes that, and we're not trying to duplicate those efforts in this amendment. What is a risk management plan? Well, it's really a document that sort of outlines what kind of activities are being undertaken on the property. It's ultimately and to try to outline how you're going to control those activities or mitigate them such that they no longer become a significant drinking water threat to that particular vulnerable area, that wellhead, for example. So it's something ultimately it's a contract essentially, or a plan that's developed between the proponent and the individual who's engaged in that activity and your risk management official. And so it's a binding document that carries forward. And that document is only attached to the individual, not necessarily the property owner. So if the property changes hands, then that risk management official plan is no longer, presumably that activity would go along with that particular individual. And if some other activity were to take place, then a new risk management plan would have to be put in place. So that's essentially a pretty significant tool that's been made available through the Clean Water Act, and again, all under the authority of the risk management official. The way we've structured these amendments, again, as I noted, that we're essentially requiring all applications and building permits to be screened by this risk management official, RMO, and they will determine whether this particular threat or one of those uses or activities that are on that long list of 19 prescribed threats actually constitutes being a significant drinking water threat. If it does, then they would either say that use is either prohibited in accordance with the source protection plan, or you need a risk management plan before you can actually have a complete application under the Planning Act. So before you can really pass go, you really need to get that notice by the risk management official. There are certain policies in the source protection plan that must be implemented, and these relate to septic systems in Norfolk's particular case. And with respect to small systems, we've included policies that require that if you can, you try to site or the new or replacement of septic systems as far away as possible on your property from the vulnerable areas. And there is a prohibition of larger systems that are dealing with 10,000 liters, so larger private septic systems. Those would be prohibited primarily, and again, in those red areas that we've identified on the wellhead protection areas. And I should just remind you, with recent changes under Bill 73 of the Planning Act, this amendment that you're implementing is not appealable. So implementation of provincial plans such as the source protection plan is not appealable. So really, in summary, what we're doing is, again, implementing. This is a conforming amendment to a source protection plan. We tried to distill this down into what is the net effect to your constituents in the area. From a farmer's perspective, the vast majority of the farmland is outside of these wellhead protection areas, or ICAs. And if there are activities within these areas, they can either be dealt with through either a risk management plan or perhaps even as part of their nutrient management plan as well. In terms of individual homeowners, residential homeowners, the policies are exempt residential uses, so the RMO is not screening individual building permits for a deck or a shed or those types of things. This is really, they're screening activities that are dealing with those 19 prescribed drinking water threats. So, and then finally, probably the biggest effect would be those on your businesses and your industrial uses, and portions of your Judd Industrial Park, for example, is located within a vulnerable area. So certain uses that are dealing with those either certain chemicals that are deemed significant drinking water threats may have to be regulated, and either in large part will have to be regulated through the development of a risk management plan. So that, in a nutshell, is a whirlwind tour of source protection plan and the amendments that you have before you, and be happy to answer any questions.
Thank you very much, Pierre. It was well presented and in good point form. Thank you. Okay, questions for council? Any questions for the planner? Oh, we've got some questions here, Mr. Chauvin. Councillor Geisens?
Thank you, Mr. Mayor. I want to go back. I read something and it was gone before I could look too, but it said something about it's not the land, but it's the individual that has the. Can we go back to that? And can you tell me what that is about? So it's not the land, it's the individual that has the, I guess, the burden to bear?
Yes, through you, Mr. Mayor. Under the Act, the way it's written is it's the individual that is undertaking the activity that is a significant drinking water threat. It's their obligation to have that risk management plan. So that if that individual or that owner moves on, and probably that activity that they're undertaking moves on, then there's no need for a risk management plan anymore.
Okay, but if that person moves on and somebody comes and doesn't know what they have to do it or whatever, how are you to deal with that, I guess? Because if it's the individual, if somebody takes over a farm that has a well in close proximity, how do you deal with that?
Through you, Mr. Mayor, that's a great question. And what happens is under the Clean Water Act, as I mentioned earlier, there is the authority to deal with, that would then constitute an existing use. And so your risk management official has the authority to then renegotiate that risk management plan with that new owner, dealing with it as an existing use.
How do you know, or whoever has to do this, how do you find out that the individual has gone? That's the next question, I guess. And how do you deal with that?
Through you, Mr. Mayor, another excellent question. There are a couple tools you have. In some instances, there may be a change of use permit that will be required, and so that would then sort of trigger a flag, or perhaps there's a building permit that's required, or perhaps if there is even a planning permit or planning application, then those would trigger those. But if there's none of those, it is a bit of a challenge, and it's really up to the risk management official to stay on top of those types of changes. And I don't know if there's anything else in terms of the county.
Well, I guess I was
Monitor
thinking that
those.
it would be more advantageous to have it done on the land. The individual can leave, but the land can't. So I'm not sure how that